It appears that U.S. immigration policy regarding people who entered the U.S. on ESTA is rapidly changing, and it doesn't really make sense. Let me explain. So, ESTA is a Visa Waiver Program. If you're from a bunch of different European countries and some other countries around the world who have good ties with the United States, usually are economically stable, have the option to enter the US without applying for a formal tourist visa. The most common version of this is called ESTA. Let's say someone enters from the UK, right? They usually won't need to apply for a tourist visa. They can just register online for ESTA, get approved, and then enter the US without any visa at all. But there are different requirements for ESTA and different limitations. One of the limitations is you can typically only enter for 90 days at a time, and ESTA can just be revoked summarily. I mean, that could happen with a tourist visa too, so actually that's not a big difference, but the 90-day limitation differs from a tourist visa, which typically lets you stay for a maximum of 180-day duration of stay. The other major difference between a formal like B1, B2 tourist visa and ESTA is people who are in the US on ESTA out of status can be summarily deported without a right to formal removal proceedings where they can contest their removal in front of an immigration judge. But something really weird is happening. ESTA overstays are getting notices to appear in immigration court, which makes no sense because they don't have a right to removal proceedings. I mean, we as immigration lawyers are happy this is happening because it gives them an opportunity to apply for adjustment of status as a defense from removal and other defenses from removal. But, it's debatable whether or not they even qualify, and it doesn't make sense why the government is doing this when these people aren't eligible for defenses from removal, with some limited exceptions, like relief under the Convention Against Torture if you believe you're going to be tortured if you go back home. But that's a very high burden to meet. And these people are coming from super stable, economically prosperous countries where they're not going to probably be able to make those arguments successfully. Let me give you a quick example of a case that just happened a colleague shared with me. So someone enters on ESTA, they marry their US citizen fiance, so US citizen spouse, they file for adjustment of status, marriage-based adjustment of status. While the case is pending, they get into a massive fight, and the US citizen spouse withdraws her I-130 petition, which immediately results in the I-485, which is the application for a green card permanent residence, to get denied. As soon as it got denied, it automatically triggered a notice to appear. And then this attorney's posting this in our message board saying like, how is it that this person got a notice to appear? And I replied and said actually a bunch of other people, other attorneys have also recently reported this, but hey, much better than them not getting a notice to appear, because the alternative is they just be summarily removed without having a second bite at the apple. So now that they're in removal proceedings, they can apply for adjustment of status as a defense from removal, and that should be successful. So I actually think this is good. And the debate is how is it that these people are eligible for NTAs? And one of the theories is, well, there was a policy memo that says a denied I-485 if you're out of status is automatic NTA, even if it doesn't make sense. It's debatable what's going to happen at that first court date. My theory is that the Department of Homeland Security attorney might try to dismiss the removal proceedings because the immigrant who's in removal isn't subject to removal proceedings. They're just subject to be summarily removed from the United States, which is a way worse outcome. But hopefully they will have a chance to defend themselves in removal proceedings. And guys, this is only for people who are out of status. So we have tons of ESTA cases who've applied for adjustment of status before they fall out of status, and that's a totally different situation. Anyway, this is a recent development, and I thought maybe someone out there could benefit if I made a video on it. So if you guys want more videos like this where I just give you recent changes and recent updates, please let me know in the comments. And if there are specific topics you want me to cover, please write them in the comments. I will read them and make videos of them if it's something that I'm knowledgeable about. If you need any assistance with the family-based immigration matter, citizenship, green card application, or deportation defense, you could always reach out directly to us. My office handles all that stuff, and I'm the attorney, Pouyan Darian. I handle these cases nationwide. The first step would be to schedule a consultation with me by clicking the link in the video description below. And guys, if you get any value out of these, the one favor I have is please like the video to let me know. And if you don't like it, dislike the video. Give me a thumbs down to let me know that you don't like these videos and you want me to make videos about different topics, because I'm just guessing what you guys want and trying to make 5 videos a week just for the immigration community at large. So anyway, that's it for today. I'll see you next time for another video.